Freeman, Brian Wilson, Mary Catherine Ham, today's newsmakers, and you, the Morning Majority. 105.9 FM, AM 630. WMAL.
Good morning, 7:07 on a Monday, but we're trying to cheer it up for you here on 105.9 FM and AM 630.
We're trying to start you up.
That's right. That's a reference to the song.
Right,
yeah. I'm sorry. It's before my time.
Yes.
I'm just kidding.
Oh, come on. It's classic.
But it's
I'm
still
messing with
classic.
you. It's a Microsoft commercial, right? Anyway.
Wow, yeah.
So we got Joe DiGenova on the line, our legal expert. How's it going, Joe?
It's going fine. I'm leaning forward.
Nice. So
if anybody could tell me what that means.
Yeah. This was the week that we were supposed to hear all the goods spilled from the Solyndra guys.
Right.
But they have unexpectedly pled the fifth. So what does that mean from here on out?
Actually, it was kind of expected.
Well, they had claimed they were not going to do that, and then they changed their minds.
It was inevitable that these guys were going to take the fifth because there was no way they could testify after having sent the committee letters recently indicating that the company was in fine financial condition and was going to move forward and expand and all of that. They clearly sent letters to the committee which were at a minimum misleading and perhaps even false, and those letters constitute evidence in an ongoing criminal investigation, and there was no way they were going to testify. Actually, the best part of the hearing, though, was Henry Waxman, the badgerer-in-chief, complaining about the Republicans asking questions of people who had taken the fifth. This is the most galling thing for anybody who has watched Congress, and of course the mainstream media gave Waxman a complete pass for being totally duplicitous when he was chairman of the committee. And over the years, he has been one of the most obnoxious, badgering questioners in the history of the committee. He insulted people who took the Fifth Amendment, and for him to criticize the Republicans for continuing to ask perfectly legitimate factual questions was simply outrageous. The big problem here for the White House, however, is that Solyndra has a very ugly history of involvement by the White House and Department of Energy people in the most important decision of all. Once, PricewaterhouseCoopers in March of 2010 said the company had bad finances. It was shortly after that audit that the president went out and gave his famous May 28th speech pumping the company. Immediately after that speech, the IPO, which had been planned, the initial public offering, was canceled, and in February, somebody at the White House and the Department of Energy restructured the loan so that the taxpayers became last in line in violation of federal law. This is all going to be the subject of the ongoing grand jury. Solyndra will live. It's not going away. Yeah,
I'm getting the impression, Joe, that as you look at it with the prosecutor's eye, that you're beginning to believe that there's a very good case here, that there was something not quite right going on with Solyndra.
Well, I think there's just no doubt that the Solyndra executives and their people involved in putting out material public information about the company misled investors.
Does it get into the Obama administration in a serious way?
It has to, because of the restructuring of the loan.
How are they even...
The loan actually violated federal law. Under federal law, the taxpayers are supposed to be number one in priority in a bankruptcy. They made them last. The Obama people put the taxpayers last and put the Obama fundraisers first.
Does the holder Justice Department have the integrity to actually go after this in the way it needs to be gone after?
I think they do. I think the execution of the search warrant by the FBI at Solyndra and the bracing of Solyndra executives at their homes by the FBI shows that a federal judge has already ruled that there is probable cause to believe that a crime has been committed. I think the department is now locked in to the traditional investigative mode, and that there's no way this doesn't go forward.
Joe, since the donors, the Obama donors and friends, have gotten first dibs on the assets for this company, while they're under investigation, can they make good on that? Or is there a chance that the loan structure could be reversed and that taxpayers could get paid off first?
Well, actually, the bankruptcy judge has authority over all of this. The company really doesn't have any authority anymore. Once they go bankrupt, the bankruptcy judge takes over. And however, the bankruptcy judge cannot redo the agreements that have been made about who gets paid. There's an outside possibility that the judge could rule that restructuring is illegal, and indeed there is a basis to believe that it was illegal. But whether or not a bankruptcy judge will do that remains to be seen. But they could very well pay the contributors and investors who got priority, which they should never have gotten legally. But because of all the publicity surrounding this, the bankruptcy judge may step in and prevent that.
All right. Last week, Joe, we were talking about this Walgreens case where a pharmacist was told in part of his company policy that you're not allowed to bring a gun to work and that there's a non-escalation clause, meaning if somebody breaks in the place, you just let them have at it.
Right.
He did have a gun. He had a carry permit, and he used it, and the robbers left the building, didn't really get anything, and nobody was hurt. Walgreens then fired the pharmacist for breaking company rules. He is now suing. The pharmacist is now suing on his Second Amendment rights being violated. Does he have a case in this situation?
No. Company policy trumps his right to bear arms. Nobody says he doesn't have the right to carry a weapon off duty, but he has a contract with Walgreens, and that contract is we will pay you to be a pharmacist, and you will obey our rules. There's nothing in that contract that allows him to carry a weapon, and he cannot violate company policy. And this is a fairly serious matter. If a company has a no-gun policy, that's fine. They're entitled to have that as part of their employment contract. They can do anything they want as long as it's within the law. Mm-hmm. He cannot violate that policy. While I love the guy, and I'm glad he did what he did, and I think he's a hero, he probably violated his employment contract, and they can fire him.
But do they have a duty to protect him since they're not allowing him to protect himself?
Well, they certainly have a duty to make sure that they've done everything they can to make it to be a safe working environment. There's no law that says that they have to have security guards there, although in many pharmacies, when there are thefts of pharmaceutical products and prescription drugs, sometimes drug companies will put in security guards. Now, if this store had a history of robberies, and if they were not providing security, then he might have an argument, and we shall see how that works out.
Does an employer have the right to basically set a rule that takes away any constitutional right that you have? I mean, could they say, hey, if you want to work here, we are allowed to search your car at will. If you want to work here, we are allowed to limit your free speech at will? Generally
speaking, reasonable limitations on certain freedoms are acceptable as part of employment contracts. You cannot, however, you can say to people that they cannot talk about political issues on company time when they're dealing with customers, because that interferes with the conduct of your business in the way you want it conducted. Now, you can't control their speech off premises unless they bring the company into their free speech off premises. So these are complex issues, but generally speaking, employers have the right to have a contract. You've entered into it. You signed it willingly. You know what the limitations are. And when it comes to weapons, which really are not speech, you've made a pretty heavy decision, understandable one in many circumstances. But if that's against company policy, you can be fired.
So it's a reasonable limitation.
Yes, they have to be reasonable, generally speaking.
All right, Joe. Always good to talk to you. Thanks.